We're going to convene the meeting of the Mendocino County Retirement Association Board into session. And first thing on our agenda is roll call.
Ms. Schattmeyer is absent by prior arrangement. Ms. Forrester?
Here.
Ms. Cavanis?
Here.
Mr. Jurdy?
Here.
Ms. Smith?
Here.
Mr. Cromer?
Here.
Mr. Shoemaker?
Here.
Ms. Harris?
Here.
Mr. Anderson?
Here.
Thank you.
We'll do Pledge Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one
nation under God,
Under God,
indivisible,
liberty,
with liberty and justice for all.
All right, thank you. Next on our agenda is public comment on items that are not on today's agenda. Do we have any members of the public who wish to comment on items that are not on today's agenda?
I see no public comment at this time.
Okay. We're going to go to the consent calendar. We have the minutes of August 18th, 2021, August 2021 retirement report, and the preliminary monthly financial report. Are there any items that people would like to discuss? Okay, not seeing any. Do we have any members of the public wishing to comment on the consent calendar?
I see no public comment.
All right, well, then by acclamation there, the consent calendar is approved. We're on to discussion of the historical benefit review, project status report, and project updates.
Good morning. Thank you, Chair Jurdy. The historical benefit status update report is in your packet. This month's report reflects the large mailing for retirees who may not have been offered options 3 and 4 at the time of their retirement. Of the 381 individuals who were sent that notice, 19 have expressed interest in receiving an illustration of what one of those benefits would be, and these numbers reflect that updated mailing. If you have any questions regarding the report, I'm happy to answer any questions this month. Because the majority of these folks didn't have any specific action to their account because they weren't interested in even exploring the option, that's why the report reflects a large group of account case numbers together, because there was no action by the member.
Thank you, Doris. Julie, you have a question?
Yeah, I was just looking at the spreadsheet, and maybe this is what you're referring to, Doris, but the correction date after August, where it has the @ sign and DOR, what does that represent?
Some of those individuals had a correction processed outside of the Alameda mass mailing for active employees because we handled them out of cycle at the date they retired as far as active employee refunds. We processed the refund right before we processed their retirement, and they weren't part of the mass Alameda mailing. I didn't have the specific individual dates that we addressed those with the member at the time they were retiring, but that's what that meant. We corrected their refund of the Alameda contributions at a retirement essentially during that process.
So date of retirement is what DOR is, date of, okay. And then just one more question. Looks like we have 919 completed. Wondering what the bulk of it is. Did I get this right? There's 1,003 left to correct.
That's correct. The majority of the remainder are inactive accounts that had omitted interest that we're correcting for. Of those 743 inactive corrections, almost 496 roughly, are people who actually have taken a refund, but we're correcting accounts where the member had refunded if they missed interest during the time their funds were on deposit. So those we will correct en masse, and they'll be notified at the time we post the correction to their account. We anticipate that to be November.
So that's number 17 and here in the
Yes.
numbers. Okay, thank you very much.
Thank you. Quincy?
Thank you, Chair. The options that we were given to a large percentage of those 400 and some this last month, what time frame did they get to make a choice if they wanted to explore those other options?
The majority of them were given a month to let us know if they wanted to explore those. We had a few instances where they required a special letter, and those letters did go out late, and they were given, I believe, 2 weeks to respond to us. If someone did contact me now and said they still wanted to look into researching one of those, we could certainly pass that along to the actuary for calculation. I did not expect there to be a lot of interest in these options. We do have 19 requests in total so far.
I didn't anticipate much interest either, but I just didn't know if you put them on the list, if they never communicated with the Retirement Association saying one way or the other if they were interested or not.
And I did, and that is on page 18, where it indicates the case number goes from like 457 or 470 to 829. That's the mass group that didn't respond to the notice.
Okay, so if for some reason they didn't get the notice and they didn't know of that option, they reach out later, they could still have that option.
Certainly, I think that we will certainly work with the member if we can get a response within the window of our compliance statement, certainly.
Okay. Thank you.
Thank you. Any other questions? I'll turn it back over to you, Chair Jerdy. Thank you.
Right. All right, well, the next, but do we have any public comment on the historical benefit update?
There is no public comment at this time.
All right. Well, then we're going to go to item number 4, which is consideration and action on appeal of domestic relations order correction notice by Tony Cochran, retired recipient. And I think first we'll go to Doris for the summary of the report. And can you invite Ms. Cochran into the meeting?
She is in as an attendee and can hear. She had indicated to me that she would prefer not to actually speak, but is available to answer any comments you have. I do have a statement from her that I would like to read. I also provided in your board packets a summary of the situation, my earlier correspondence with her. And if you have any questions regarding that, I am available to answer questions. And again, Ms. Cochran is on the phone. Ms. Cochran's statement says that she has been receiving my share of the retirement ordered by the judge in our divorce settlement for 24 years. I made financial decisions based on the monies awarded me by the court. Now 24 years after the fact, and way too late for me to change any decisions I made at that time, you find a glitch in wording and want to clarify the rules. My ex-husband and I were married for 22 years. I was never advised I would not receive my money for my lifetime until August 17th, 2021. Obviously, mistakes were made by M. Sarah, or you would have not felt obligated to send out the August letter. Had this been made clear to me at the time, my attorney and I would have done things differently. I strongly feel as long as Bruce's retirement account is active and benefits being paid to his current wife after he passes, I should also receive my awarded portion. His passing should have nothing to do with my judgment by the court. As long as the retirement account exists and is active, paying out a benefit, my judgment should stand. It may not seem like a lot of money to you, but it makes a great deal of difference in my monthly finances. Maybe to be equitable, I could be awarded a portion of the benefit given to his current wife. I feel cheated out of what is rightfully mine due to the massive confusion you folks created after 24 years after the fact. If I were your mother or your grandmother, would you feel it would be fair for me to lose my monthly money? Please make an equitable, fair, and righteous decision in this matter. According to the information Doris sent me, you, the retirement board, have the power to judge in my favor, or at least work something out that would be fair and equitable for me if you desire to do so. I would like to point out there was a lot of confusion and errors that occurred in this situation. At the time of the divorce, Ms. Cochran's attorney was notified that we do not do split accounts like the PERS system. That information may or may not have made its way to Ms. Cochran. However, County Council then provided the attorney with a sample DRO that was one from San Mateo that used split account language, and the DRO was drafted and submitted to us, at which point the retirement system said, we don't do split accounts, and they took out one paragraph that referenced some specific code sections of the serial, but they didn't change the actual language describing Ms. Cochran's benefit, and it still used the separate account language. It was then administered as our standard shared benefit methodology. With the shared benefit methodology, the payments may be able to be continued if a continuance is payable after the member's death. The letter that I sent Ms. Cochran with my initial determination on the objection was that the court retains the ability to modify that DRO, and it could be modified if she went back to get that mentioned. It was not mentioned in the DRO at the time it was filed because there wouldn't have been reason to, based on a separate account language. Of course, Ms. Cochran feels that she shouldn't bear the cost of having to go back to court to clarify something that was truly not her fault at the time that the benefit payments began back in the late 90s, I believe.
Jeff? You're muted.
Yes, thanks. So I wanted to point out a couple of things. I think we've had one of these appeals before, maybe two, but I wanted to mention that in this proceeding, I have not worked with Doris on this case. She's worked with fiduciary counsel. I am the board's counsel, and I will be going into closed session with you to deliberate, and Doris will not be there. I do have some questions. My first question is kind of a legal question, and I know Ms. Cochran perhaps doesn't want to appear, but I'll ask both sides. Am I understanding it correctly that at this point in time, there is no harm to Ms. Cochran? The event that may need to occur hasn't occurred yet, and it could occur in the future, and maybe it could not. And that talks about when her benefit gets extinguished. Doris, can you address that issue, please?
Yes, I can. You are correct, Jeff. Currently, Ms. Cochran is receiving her benefit and will continue to receive that benefit until her ex-husband happens to pass. Should she survive him, that's when her benefit would be affected.
Okay, so the legal term is called ripeness, and there's an argument for the board's information that the case really isn't ripe yet. But I appreciate the seriousness of the situation to her, and I I'm looking at the merits now. So am I understanding it correctly that the county has not adopted the particular code section that would allow her to be able to get the benefit, but that if she were to go back to court and modify the order that the judge approved, she could still get that benefit. Is that correct?
Yes and no. I'd like to separate the two issues. The Board of Supervisors has not adopted Article 8.4 of the county retirement law that grants the systems the ability to administer split benefits. The issue of whether or not the community property portion awarded to Ms. Cochran continues if a continuance is payable was not addressed in the DRO, as it often would have been in a in a shared benefit division, because the language in the DRO was split accounts, not shared benefit account.
So does Ms. Cochran need the approval of her ex-husband to go back into court and ask the judge to modify the order? Is there any reason why that wouldn't happen?
I can't answer any of that.
So that's a bit of an open question then.
I am unable to answer that question. Legally, I don't know if it requires his agreement to reopen it. I don't know if he would agree to if it was required. I don't think that it would be, but again, I'm not a lawyer. You know more about probably divorce paperwork than I do. So part of her concern is also that she doesn't have necessarily the finances to allow her to go back to court and address this. It is not addressed in the DRO because the DRO followed a format for a different type of division.
Thank you. Any questions? Did the trustees have any questions for Doris or Ms. Cochran?
Richard?
So the agreement on her getting a retirement benefit was determined in the DRO. Is that correct? Not by MSARA?
We have marital settlement agreements as part of the divorce decree itself, and we also have the domestic relations order. The retirement system technically just administers what the parties agree to. We don't, in theory, have control over how the asset is divided. The language in the DRO talked about awarding Ms. Cochran a specific amount or percentage of the member's contribution balance and years of service. We do not do that. That is a split benefit formula. But when they had that DRO, they had then administered it as a shared benefit formula, which was utilizing a formula of the ratio of how long they were married compared to the total length of the member's employment multiplied by 50% to get a community property share that was applied to then his benefit. Did that answer your question, Richard?
I think it did, but I'll ask maybe a little different too. Is so the county, the retirement system, took the DRO and implemented as the judge ordered, and that was done not based on the serial, but based on the court order.
I would say potentially no. The domestic relations order filed with the court specified a split benefit.
Okay. Okay.
They attempted to correct by removing one paragraph from the initial one submitted, but just removing that paragraph, they didn't fix the other portions of the DRO that were not consistent with the ability of MSARA to administer.
Does the outcome of this in the members passing affect the benefit of the current spouse? And I'll add, if this continues with Ms. Cochran, would her continuing to get funds affect the benefit of the current spouse?
Currently, if Mr. Cochran passed, his ex-wife's benefit would terminate.
Right.
If the relief is granted, that yes, she is entitled to her community property share of the estate of the continuance of his survivor, then in the event of Mr. Cochran's death, the survivor benefit payable to his current spouse would be split, and it would be reduced by the community property percentage that would have been awarded to the ex-spouse. Does that answer your question?
That does. Thank you.
Julie?
I didn't see the letter from April 28th, 95 from Ms. Cochran's attorney that acknowledged that it was separate retirement accounts. So I was wondering if maybe you could talk about that a little.
Certainly. I was trying to limit the volume of materials to make public as part of the discussion here today. There is a letter from her attorney in the mid-90s that said that the attorney thought Sarah was wrong in saying that it couldn't administer a split benefit because PERS does, and he thought it was required, although in our case, the Board of Supervisors had not adopted that optional provision. But he said that based on what our process was, he did understand that we do not do a split account, and that he thought that his client might be okay with that, more or less, to paraphrase what the letter said. I don't have it in front of me right now. I'm working from home. I apologize. I'm having some network issues and couldn't get connected to the county site.
Okay, so I mean, to me, I guess that would be helpful to see if Ms. Cochran was copied on that letter to her attorney. But also on the DRO was signed by our administrator at the time, and I believe that MSARA was county at the time, so our county council is the one that provided the DRO format from San Mateo. So I guess I just want to make clear that when we're talking about MSARA, it wasn't a separate agency at the time. It was the county, and county council is the one that provided this form.
That is correct. And I can say that Ms. Cochran was not copied, to my knowledge, on the letter from her counsel to the retirement system. Nor did I see her copied on responses that went back from the retirement system or county council to the attorney. The sample DRO is actually part of the court records with a it wasn't an interpleading. I don't know the legal term, but it was submitted by county council at that time.
Doris, would you like me to look that up?
I think that might be helpful if you could just pull those up and either make them available to the board via email, so they might have it for closed session, or confirm that, again, Ms. Cochran wasn't CC'd on those correspondences.
Okay.
Most of them I have separated, except for the large file that's like 57 pages. I don't think you'll need anything in that file.
I'm looking at the 1995 letter that Julie mentioned initially.
From Ms. Cochran's counsel.
Well, this looks like it's from, yeah, my client, Tony. And it was addressed to the spouse and CC'd to Tony.
It was.
Yes.
That's not a letter that came to the retirement system. You said it was addressed to the spouse.
Well, it's regarding the two of them. It's addressed to the retirement system. And it was CC'd to Tony.
Okay. So I stand
Mm.
corrected. She was copied on that correspondence, it looks like, from her attorney.
Jim and then Richard.
Off mute, yes. Doris, just to be clear for me, as I understand it, is that in setting up the separate accounts, that would have required a Board of Supervisors action, which did not occur. Was there anything in the retirement package that of the spouse that in any way indicated any language that the board may have approved such separate accounts?
No.
Does everyone have access to their closed session items in Filer? No. The best way for me to get this information out to the board now in time for closed session is to keep it confidential and keep it in Filer. Otherwise, I have to go through all the documents and do a lot of redacting. So I don't know that that's feasible at this moment, unless you'd like to take a break.
Judy, I think we can go into closed session, and if it's an issue, we can address it when we return, unless any of the trustees feel differently.
Thanks, Richard.
So to that degree, we could also you could screen share it during closed session. That might be a way to do it. So my question goes to Mr. Cochran. If we make whatever decision we make here, is he a party to that decision? Because it sounds like it might affect his current spouse.
I would refer that to council.
I think that's something we can talk about in closed session.
Quincy?
Thank you, Chair. I want to make something clear, and then Jeff, please interrupt if I'm saying something incorrect, or Doris. I want to make it clear for everybody on the board and Ms. Cochran that Article 8.4 of our SERL has still never been considered or adopted by the Board of Supervisors, and is, even if this DRO came before the board currently right now, it still would not be allowed with the current language of the SERL, because we have never allowed bifurcated accounts because it's never been adopted by the board.
Are you asking that as a question?
I'm making it as a statement, and I'm hoping that it's correct.
It is correct.
Okay, thank you. And I just wanted to make that apparent to everybody else, because it is something we have talked about long before Ms. Cochran brought this issue to the board, and it's still never been resolved.
If there are no more questions from the trustees and no more comments from Doris or Ms. Cochran, we can go into closed session.
Judy, are you seeing a hand raised by Ms. Cochran?
No, I'm not at this time.
Could
So
someone reiterate what the process is when you call in by phone to raise your hand?
I believe Tony has to click *6, or was it *9 to
Normally,
raise hand,
normally *6 would unmute your phone.
unmute. I can, I'm going to allow her to speak. Tony, would you like to make any comments at this time?
I think she's still muted.
No,
Tony?
I have no, yes, I have no more comments. Thank you.
Thank you very much. Tony, I'm going to ask you to go ahead and leave the meeting so we can go into the closed session. And you're welcome to call in when we're done if you'd like to continue to participate. and hear the outcome after closed session. If I disconnect you at this point in time, you may be, unable to rejoin. So if you can voluntarily do that on your own, I'd appreciate that.
You want me to just hang up the phone?
Yes, and then once you hang up and we go into closed session, you can come back into the meeting in about 10 minutes or so.
We can
So in
notify
10
her when
minutes?
we,
Yeah, we'll notify you. You can call back in.
Oh, okay. Okay, thank you so much. I appreciate your time.
Thank you, Tony. Okay, I'm preparing everyone for going into closed session.
And Doris, you're going to leave the meeting at this point?
Yes, I'm going to leave the meeting. She'll remove me and put me on hold when she also handles the rest of the attendees, right, Judy?
Mm-hmm. Yes. Well, I'm having a little difficulty, so bear with me here. It's not allowing me to promote my attendees up to panelist.
who are you trying to promote at this time?
In order to move them to the waiting room, everyone has to be promoted to a panelist.
Oh,
And we seem to still be experiencing the earlier technical issue. Okay, it's very slowly but surely working with me here. Hmm. Okay, so as far as attendees go, I still have Judy Boyette and Kendall Smith in as attendees right now, and I'm having difficulty removing them in order to allow us to go into closed session. Kendall, I may have to ask you to disconnect and join the meeting. Give me one more moment to see if I can get you to promote up here.
Judy Boyette is our tax counsel. We can ask her to leave and call her when it's time for closed session. So that would be easy.
Yeah, she's okay for now.
The other closed session. There we go.
Yeah, it's just not allowing me.
Hi, this is Nancy Hulu. I just want to make sure I'm in the correct closed session as well. So I don't see Ashley Dunning or Judy Boyette. So if I need to be kicked out of this closed session.
Right, we're not quite ready for you yet, Nancy. So you can either disconnect or you can rejoin.
Nancy, the board is going into closed session on a different matter right now. It's not the litigation closed session. It's an appeal case.
Yeah, I think I was just promoted into this by accident. So I'm gonna exit the meeting and I'll see you all later.
Thank you. So Kendall, I'd like to ask you to leave the meeting at this time, and I'll let you know when you can come back into the meeting. Otherwise, I'm going to have to. Yeah, thank you very much. Okay, now I'm moving folks into the waiting room.
Is Ms. Cochran present?
She's not come back into the meeting yet.
I just called her to let her know that she could dial back in. My apologies.
Judy, there's a phone number listed. Do you think that's Ms. Cochran?
Oh, it could be her. Yes.
Are we ready to proceed?
Yeah, so we've had a lengthy discussion in closed session, and the board has asked Counsel Jeff Burke to read the proposed motion.
So the proposed motion is to deny the appeal without prejudice, and it can be refiled in the event of one of three things. Number one, once the case becomes ripe, meaning that Ms. Cochran is not impacted at this time. Number two is if the county decides and does adopt section 8.4 and it applies retroactively. Or three, if Ms. Cochran receives an order modifying the domestic relations order. So that would be a motion that a trustee could make.
So moved.
Second.
Okay, we've got a motion and a second. Can we have roll call?
Yes. Ms. Forrester,
Yes.
Ms. Cavanis,
Yes.
Mr. Jurdy,
Yes.
Ms. Smith,
Yes.
Mr. Cromer,
Aye.
Mr. Shoemaker,
Aye.
thank you. Ms. Harris,
Aye.
approved.
Okay, that takes us to item number 5, discussion possible action regarding investment matters, and that includes our monthly investment performance report.
Good morning, trustees. Before you, you have the monthly investment report. As you can see by the report, at the end of August, the portfolio ended just shy of $708 million. The total fund had a return of 1.48% versus 1.74% for the total fund. The U.S. domestic markets continued their upward trend in the month of August, setting market highs in the Dow Jones Industrial, the NASDAQ, and the S&P 500. All three major indices spent August well above their respective 200 moving day averages. That 200-day moving average is an important technical signal because it breaks above or below this level can signal shifting investor sentiment in the respective markets. However, this marks the 14th consecutive month with continued technical support in those markets. Short-term treasury yields were either flat or lowered just slightly. while the longer-term rates gradually increased. For example, the 10-year Treasury started the month at 1.2% and ended at 1.3%. The 10-year Treasury is thought of as a proxy for the 30-year mortgage. The dollar also appreciated over the month. As you may have heard in the news, the August non-farm payrolls rose by only $235,000, 235,000 jobs. This was well below the consensus estimates of somewhere around 700,000. According to the BLS, the majority of the increases for the month were in the professional and business services industry. These jobs would include architectural and engineering services, computer systems design, and scientific research and development, and office administrative services. Transportation and warehousing and the air transportation industries also increased. These would be things like couriers, messengers, and warehouse storage workers. Additionally, the private education industry also contributed significantly to that increase. Unfortunately, the only jobs that are actually above pre-pandemic levels are the transportation and warehousing sector jobs. The U.S. unemployment, according to the St. Louis Fed, dropped for the second consecutive month in August to 5.2%, down from 5.4% in July. The unemployment rate has dropped 6 out of the last 8 months. On the inflation front, prices in the West region, the region that we use to calculate the retiree COLA increases, crept up 0.19% in August to 4.99%. And while that is higher than probably most people would like to see, it has significantly slowed down. So that's a good sign. According to the BLS, the August increase was influenced by higher prices for shelter and gasoline. Year over year, the August inflation rate is 3.5 percentage points above where it was last year. Last year around this time, there was a fair amount of deflation actually measured. And so that large increase of 3.57% partially reflects that. That's a basic update on what's been going on in the markets. Did any trustees have any questions about the monthly investment report?
I'm seeing any, Robert. Judy, do we have any public comments on this item?
There's no public comment at this time.
Okay. And then Robert, as you also have an investment manager presentation.
Yeah, like I outlined in the memo, the board has essentially completed the previous work plan on investments and education. And so we just wanted to get a sense of how the board feels about bringing in managers for presentations and, you know, the appetite in general for updates with regard to the investment portfolio. So I just wanted to get some feel for where the trustees are in terms of that desire.
Okay, thanks. Jim and then Kathy.
Robert, I appreciate the information, and I appreciate you kind of setting out this menu for the trustees. Speaking for myself, I think with all of the other work that we're doing, is that option number 2 of working with Callan and having managers brought in as staff and in collaboration with Callan see a need. For me, I think that would be the preferred alternative.
Thanks. Cap.
Jim, I agree with what you said as well, but I also want to emphasize that when we have the opportunity, because of something going on in our portfolio or with Callan, when we have the opportunity to learn something on the current trends, I'm looking at like 3C, like we did a couple of, well, maybe it was last month or the month before about ESG. When we have that opportunity to learn things about the changing landscape in China or the developments of, you know, the investment of what's happening in infrastructure, I think that's important, at least for me personally, because I don't keep up on it on my own. And so as it applies to our particular portfolio, I would like to learn more about the different types of investments that we have.
Trustee Smith, was there any sort of, going to item number 4 there, is there any sort of topics in specific that you may be interested in?
Not anything in particular. It's just, you know, I hear headlines on the news about how this or that might be affecting our investments as a whole in this country. And so when there is something major out there, I think it's appropriate that we learn how it might affect our portfolio at the retirement board.
Are there any other trustee thoughts on that? Any other topics from in specific?
Richard?
Well, to the concept of, you know, some pretty basic education about each one of our investments through the managers, not necessarily with the managers, but if we had questions about philosophy, then yeah, pull them in and let's talk. And I think that Kathy's statement about, you know, current events, though current events can change wildly between our meetings, that's for sure. But I think that's an interesting educational approach as well. So I guess that's a modification of Jim's, but supporting Jim's comments as well. And it might be, as far as particular topics, you know, maybe ones to start off with, Robert, the ones that of most interest to you.
One thing that occurs to me, you know, if there are trends that you're seeing, Robert or Doris, in other public pension funds, you know, are they looking at certain things, you know, that at least we should at least educate ourselves about what those other funds are doing? Kathy?
Well, and I just want to add too, I mean, I'm not talking about, you know, a day long, like you had on their seminar about all of that. It would overload our minds. I'm just thinking about a 20 or 30-minute update every once in a while so that we can be better informed about the investments that our agency holds. So, you know, I don't want any big, long, detailed things that I can't understand without studying more. So,
you know, to that issue, I think we started using our meetings to do that, like we talked about ESGs, and I believe we're getting credit for our education. If there were a 20-minute segment in each board meeting, just regularly scheduled, I think that'd be good.
Jim?
Yeah, just quickly, I've found that when Judy's passed on the opportunities for those Callan market updates, is that it hits a lot of these things, kind of general market activity that's going on, and I think they're great topics for a board meeting and topics for part of Callan's quarterly updates. But if board members haven't checked those out, I'd encourage you to. There's a lot of good information in those.
Thanks. Robert, did you get the feedback you wanted?
Yeah, so let me just reiterate that. What I'm understanding is that possibly, well, I sort of heard two different comments on frequency of meetings. I just heard Trustee Shoemaker mention possibility of a 20 or 30-minute session each board meeting, but I also understood Trustee Anderson's first comment to go to item number 2, that the board of retirement may be more interested in only seeing presentations when Callan or staff feel there's some reason or change or something significant to talk about with regard to the managers themselves. Did I misunderstand that?
You heard both.
Okay. My suggestion would be possibly that we attempt something every quarter. Given what's going on right now, I think that would probably make the most sense. Also, some of the topics may end up being discussed at the strategic meeting, like the ESG. We're already aware that the board has identified that as an area of interest. So depending on how much conversation happens between whenever that meeting is and now, obviously we're going to keep all the options in mind with regard to topics. But my suggestion would be, getting back to the schedule, would be attempt to work on something quarterly for the board that involves both trends in other systems as well as management and processes within each one of our individual managers. Is that kind of where the board feels that they'd like to go?
Looks like that strikes a good balance.
Yep.
Okay. Great. Great. Well, we will definitely keep that in mind, and I'll work with Doris and Callan, and we'll make sure to work a schedule out that where we'll probably try to bring the items to the board on months where there's less activity, where we know that there's less action items specifically. That way, there's no, that way there's just less tendency to feel the need to act, just to keep things a little simpler. So that would be what I would have the board expect in the future. Is everybody okay with that? Let me just go to speak to one other item with regard to updates and manager updates. We recently were informed by our emerging market manager 91 that they're going to be shifting away from their current pay structure within the fund. And so I'd like to just briefly read their correspondence to the board. That way the board's aware. When 91 was originally launched, they were called Investec at that time. Their commingled vehicles were initially launched. They were structured in a non-standard manner where Investec 91 pays each fund's operating expenses outside the fund from the all-in fee invoiced to each investor. For us, that would have been the 80 basis points that we're currently paying each quarter. That is not the industry standard, though. The industry standard for commingled funds is to charge the operating expenses inside the fund via an accrual against the fund's net asset value. Separately, investors are invoiced an investment management fee to cover the manager's investment services. To date, none of 91's operating expenses are charged inside the fund. Instead, we're invoiced an all-in fee, which covers the investment management services and all the fund expenses. That's our 0.8% that we're paying today, 80 basis points. Effective October 1st, 2021, 91's transitioning their U.S. commingled vehicles to the industry standard and amending each fund's documentation to allow the operating expenses to be charged inside the fund. Going forward, 91 has made the commitment that we will not be paying more than the all-in fee that we're currently paying today. They intend to honor our all-in fee by doing an annual reconciliation of the fund's expense. They're basically going to credit us at the end of each year to make up the difference. There could be the possibility that that the expenses could increase, but within the fund, the operating expenses could increase. But 91 has made the commitment to us that they're going to perform a year-end reconciliation in order to ensure that our total fee does not increase above the 80 basis points as it is today. In terms of the direct fees that we will be paying, that fee is going to go down slightly from 80 basis points down to 73 basis points. So there will be a slight appearance of slight savings in terms of the direct fees that we'll pay to 91. But it's our expectation and Cal's expectation that over time that net fee performance should be the same. In a perfect scenario for us, that credit will actually lower our fees paid. So I just wanted to update the board about that. They're going to be changing to a industry standard format, and in a best case scenario, we'll save a little bit of money. In the worst case scenario, we'll continue to pay the same amount. And so Callan is not concerned, and we're also not concerned with the change.
Robert, the reason for the change is because they want to go to, or the need to go to the industry standard?
They don't need to. They decided that they want to because when they go to actually try to get new business, it doesn't look good when they have to explain we're very special and we're not doing what everyone else does. I get the sense, it's somewhat off-putting for new investors. And so they basically want to conform to the industry standards so that they don't have to have that conversation with potential new investors.
All right. Do we have any public comments on this agenda item?
There's no public comment at this time.
All right, then that takes us to an update of our placement agent disclosure policy. Is this you, Doris?
Thank you, Chair Jurdy. Robert can feel free to jump in here if he has any comments. It's time for the regular triennial review of the policy. Robert did look at what other retirement systems are doing. Our policy is fairly standard as far as the items in the content of it with what other jurisdictions do as part of their placement policy. And the only changes to this were just simply being reflecting the review by the board and the new date. There were no changes to content.
Yeah, just so the board's aware, the Board of Retirement is aware, I did look at a number of other entities, a few even across the United States, and found that by and large, almost every portion of the investment policy or the placement agent policy is the same. Short of a change in maybe a time frame, those were the only changes. But largely, everything is almost exactly the same.
Hey, Jeff.
I'll just mention that I drafted it about 10 years ago and I'm getting PTSD looking at it. it was complicated. I mean, it was an important thing, and we worked with the other 37 Act Council, and so yeah. And I'm not sure actually, Robert, maybe you could speak to it. I don't want to get too deep into it, but do we really even work with those types of investments that could trigger the placement agent policy and require the disclosure?
We don't. That's primarily with private equity. Both of the infrastructure managers did complete the placement agent form, and they're not using placement agents. So yeah.
Okay. Do we have any public comment in this agenda item?
There's no public comment.
Right. Would someone like to make a motion to adopt the policy?
So moved.
Second.
Can we have a roll call?
Ms. Forrester,
Yes.
Ms. Cavanis,
Yes.
Mr. Dirty,
Yes.
Ms. Smith,
Yes.
Mr. Cromer,
Aye.
Mr. Shoemaker,
Aye.
Ms. Harris,
Aye.
approved.
All right, that takes us to item number 7, the administrative report.
Thank you, Chair Jurdy. In this month's administrative report, there's an update on our COVID protocols. We do have most staff working hybrid schedules with 2 to 3 days in the office and remote working the other days. We have one worker who has currently been working entirely remotely. We do serve appointments. We serve members by appointment. We do have walk-in traffic a little bit, and those are all served at our lobby service window. Our office complies with all of the county masking requirements for working in the office. I did have a question from a trustee about what occurs if a disabled retired member is found to no longer be disabled. I went over that briefly with the trustee. I wanted to know if there was any interest from the board in receiving a short educational presentation regarding that at a future meeting. If that trustee had questions about it, I thought there might be other trustees who also might have those same types of questions. And then also, are there any other items that the board would actually like to hear about in the coming months so we can build those into the agenda?
Jerry?
I'd be interested in a short presentation on how we handle the person who is no longer disabled, what the parameters are, and maybe there are only 2 board members, but it is something that interests me.
Yeah, be interested as well. Kathy?
Yeah, I just want to say I'd be interested as well. I didn't have the question until you brought it up, but now I do have the question. So that happens a lot too.
Are there any other topics the board members would like to put forth for consideration for a short educational item at a future meeting?
Quincy?
I have interest in the original question, and I'm going to say this, but I'm in no way, shape, or form dismissing the busyness of our employees, but I still would like the 8.4 matter brought when we get the information we have requested and when you're ready to present that.
Thank you. It still is on my list. I had not forgotten about it, but
I was confident you had it.
We'll be working on that.
Thank you.
Okay, additionally, although it's a little early, I did put information in there about our holiday schedules. We typically have closed the week of Christmas because the county also does during that time, because they're not official holidays. Employees could use leave time if they wanted to take the time off. We would be closed to the public, but employees who didn't want to use their leave time would be able to go into the office and complete their work there. Also, closing early on the Wednesday before the Thanksgiving holiday. If you have any questions or concerns about the proposed holiday schedule, please let me know. The big item right now is that Sackers has announced that they will be doing their fall conference in person in Hollywood. And I would like to know if anyone is interested in attending. I believe we have Catherine down since she serves with the Sackers board for attending in person. And my understanding is there isn't a remote a virtual ability to attend. However, the sessions will be recorded and available off of the Sackers website later for viewing. But we would like to know so we can get things scheduled and reserved in case any trustees would like to attend the Sackers conference, which falls November 9th to November 12th. That does encompass, as usual, and during the fall conference, the Veterans Day holiday on the 11th.
I was wondering if it would be helpful if we mailed out, does everybody have a copy of the agenda? Because it's for the fall conference, it's almost complete. So if anybody, we could just send that out to everybody so you could take a look at what is going to be presented.
And I may be interested in attending, Catherine.
Good. That'd be nice.
I as well.
Okay. Should be interesting. If I could send out a draft agenda to everyone.
Cool. Yeah.
I'll do that today.
There's also the Sackers legislative update there for your review. If you have any questions, I'm happy to answer anything, but that would comprise the administrative report.
Okay, thank you, Doris. Do we have any public comment on this agenda item?
There's no public comment.
All right, then we have general board member discussion. Are there any items board members would like to raise? Okay, not seeing, then we're ready to go to a conference with legal counsel, anticipated litigation, significant exposure. Go into that closed session.
We should ask if there's any public comment before we go into closed session on that item.
Okay. Do we have any public comment on this item?
I'm not showing any public comment at this time. I'm working to allow Judy and Nancy into our meeting. Julie's hand's raised.
I was just hoping we could have a break before we go into the next session, just 5 minutes.
Excellent suggestion.
Okay, thank you.
We'll hope to reconvene in closed session at 10:30.
Good.
All right, thank you. Okay, we're live. Thanks for
On
waiting.
the closed session item, agenda item 9A, direction was given to staff and council.
Hey, just, did we have any public comment?
We have no public comment.
Okay. Well, then Doris, do you want to remind us, our next meeting is going to be on October 20th, 8:30 a.m. and that's a Wednesday. With that, we're going to be adjourned at 12:34. Oh, did anyone have any final comments?
I was concerned about, we had some people in our waiting room and were they called back because we had them leave, and I'm not sure what they were here for. And if we, I know Kendall was waiting and there were some other people, I noticed their names.
Right. They had left the meeting, Julie, and so, and they're not in attendance now.
Okay, thank you.
Thank you. All right, thank you.
Thanks, everybody.
Bye.
Anyways.
Take care.